Hi, everybody. Hope y'all are having a great Thursday. We are back for another Power Hour, and we're talking about Diddy. This is the day before Diddy gets sentenced. Okay, so tomorrow, 10 a.m. in New York, we find out if the diddler is indeed going to get 11 years as recommended. Okay, so there's a few things going on in the legal news world. One, we got to start with Ray J. So I'm going to give you a brief update on Ray J and the Kardashian camp going to war. There was a lawsuit filed yesterday. So I'm going to catch you up on that whole thing. But there was a complaint filed by the Kardashian family against Ray J. Ray J did say that he was going to hit them with the RICO and that it was going to be bigger, okay? No Diddy. Bigger than what Diddy is going through with his RICO charges, okay? So we're going to look at all of that stuff and go from there. The judge did deny Diddy's recent motions to dismiss the charges, a request for a new trial. The way that it's looking, it does not necessarily look like time served is going to be a thing. And then lastly, I wanted to give you guys an update on that woman, Courtney Clenney. She is an OnlyFans model down in Miami, threw a knife at her boyfriend. She's a white woman. He's a black man. He ended up dying. His name was Christian Obenselli. Her trial is fastly approaching as well. So we'll take a look at that docket and see how close we are to trial. But that's probably the next big case in 2025. And we'll end the year with that one. So I'm going to start to make some shorter videos on that. So, for those that are not familiar with that case, what happened, the background, all of that stuff. For those that are new to me, welcome. I'm AV, right? We talk about all things law, true crime, and debauchery over here, okay? A little bit of tea, a little bit of legal, and we mix it up and we explain it for the everyday people. So all really, really good stuff, jam-packed Power Hour today. Also, I will be here at 12 p.m. every Tuesday and Thursday. It's the tease. That's how you can remember it, the tease. You guys have really been asking for a consistent streaming schedule. So that is the schedule, 2 days a week. We'll also be here on Sunday for, it's your girl's birthday. It's your girl's birthday. So we will do a birthday stream on Sunday around the same time, noon. I'm at Vid Summit next week, but I have lots of time for you guys. So I will be here getting all this stuff done. Shout out to Caesar in the chat. Good to see you. Jax Ain't Right is in here. Tamara, so good to see you. She says, hey, strangers, how's everybody been? Got to give the Chatterhood some love. Miss is in here as well. Clarence is in the building. Kiana. Wow, I haven't seen you in a long time, Kiana. Good to see you. Pancake. I love that name. Pancake is in the building as well. Brother Irwin says Libra babies. That's right. Incredible Me says free Diddy. I mean, there are some people that are in the free Diddy camp. There's a few people out there. Cassie also had a pretty long witness impact statement letter that she had submitted as well. But people are kind of criticizing Cassie because, she did get the settlement. And there are allegations that Cassie participated in freak-offs without Diddy there. I need to look into that because I was not aware of that. Right. But it is very, very interesting. We do have boots on the ground in the courtroom tomorrow, so I will be able to give you guys a better update as well. Okay. Those are all the channel announcements, everything we need to catch up on. Let's get into the business with Ray J. So here's what happened. Ray J has been, I think he was on Kai Cenat. Kai Cenat just hit 1 million subscribers. He's been really working on it. And he had like this marathon of just having all these famous people on his show. Ray J was one of them. Now, we're going to go to Twitter for a second because we want to see exactly what Ray J said. Okay. On this live stream, he says something about the Kardashian family and how there are going to be charges brought against them that he is hoping to work with some lawyers and initiate. So here we go. Let's jump on in and see what good old Ray J has to say here.
This federal RICO though, KK and Chris. Ooh, the The federal RICO I'm about to drop on Chris and Kim is about to be crazy. I'm talking about, I'm on the news every day like, yeah. Meaning like I'm going to say a lot of shit.
Got a little bounce, you know, you walk with
If anybody know Kim and cool with Kim, they need to tell her now. The rain is coming. The feds is coming.
Hey, right.
The feds is coming. It's nothing I can do about it. It's worse than Diddy. It's worse than Diddy.
Mm-hmm. Y'all hear this nigga, boy?
It's worse than Diddy. The feds are coming to investigate. Yeah, because it's like, I can't be the dirty guy no more.
So that concludes the alleged clip. Couple things here, chat. He is saying that the feds are coming for the Kardashian family and that this is worse than Diddy, right? Now, this was last week. What happened after that? Well, the Kardashian family lawyered up. They got Alex Spiro, the same attorney that represented Jay-Z last year with the whole Tony Busby thing, okay? So the attorney that represented Jay-Z is now retained by the Kardashian family. It is Kris and Kim, right? Allegedly, way back in the day, if you're young and then you don't know, if you are above 30, like most of us, way back in the day, there was a tape between, and it was a sex tape. It was a tape between Kim Kardashian and Ray J. Can you guys believe that that tape came out 20 years ago? It's a 20-year-old tape. It is alleged that Kris Jenner, Kim's mom, is the one that orchestrated the release of that tape. And that is how the Kardashian family arguably rose to fame. Okay. You know, they're known for Keeping Up with the Kardashians, the reality show. Before that, I will say this, Kim's father, who is now deceased, was a pretty famous attorney. He represented OJ in the OJ Simpson trial. Really, really popular attorney in the LA area back in the day. That is the source of the family's wealth. Originally started with the father and his law practice. Then Kris Jenner, as you can see, her last name has changed. She was with Bruce Jenner, who is now a woman. Bruce has gone through his things over the years, but there was a remarriage there. Keeping Up with the Kardashians was a big part of the family's wealth. And then many personalities within the family started their own businesses. Now, everybody says that Kris Jenner was the mastermind behind the whole thing, but it kind of started there. Kim has her own empire when it comes to branding. She's got Skims, the makeup, all that stuff. Kylie Cosmetics is another big name there. You have the other sister, Courtney. I'm not sure what her business ventures look like. I know Rob, the brother, has his own business ventures. So if you think about this large family, they really became an enterprise. Now, so we know that Ray J was starting to talk about this last week. Alex Spiro starts to send out some cease and desist. And he goes, hey, we're going to give you guys an opportunity to take these streams down, to take these videos down, because it contains defamatory material and, items that were mentioned that were not true. Those streams did not come down. Particularly, Ray J is fighting back, and we have gone to Instagram with some of those clips because they exist, they're real, things like that. Let us see what news dropped yesterday because it kind of talks about this. Headlines say Kim Kardashian and Kris Jenner sue Ray J for defamation over racketeering claims. Okay. Kim Kardashian and Kris Jenner are suing Ray J for defamation after he claimed that racketeering charges against the famous family would be appropriate. The lawsuit filed yesterday in LA Superior Court and obtained by the Rolling Stone stems from two sets of comments by Ray J, who dated Kim more than 2 decades ago and appeared in the famous tape that accused a mother-daughter duo of being involved in a racketeering case. We know what RICO is. It's a federal law typically used to prosecute mobs and criminal enterprises. Kardashian and Jenner say his allegations are baseless. Let me say this because I did go to the LA records this morning to see if we could pull the lawsuit. It does typically take 24 to 48 hours to upload. As of an hour ago, the lawsuit was not uploaded yet. I'm told that it's a 13-page complaint, but here's the thing. Ray J still has an opportunity to respond. He already did on Instagram last night, and boy, is it a riot. And we're not even going to talk about social media between Nicki Minaj and Cardi B are going back and forth on Twitter. That's a whole nother story. But back to the topic here. The singer, whose real name is William Ray Norwood Jr., appeared in a documentary, TMZ Presents the United States versus Sean Combs, about Diddy, who was charged last year with racketeering conspiracy, but has since been acquitted of that count. Racketeering charges against the Kardashians would be appropriate. That's what Ray J said in the documentary. If you told me the Kardashians were being charged for racketeering, I might believe it, he added. The suit also points to the R&B artist's claims during a live stream with Christian Rock on September 24th. That's the clip I just showed you guys. The federal RICO I'm about to drop on Kris and Kim is about to be crazy, Ray J said in a now viral clip. I'm talking about, I'm on the news every day. I'm going to say a lot of shit. Anyone that is cool with Kim, they need to tell her now. The feds is coming. There's nothing I could do about it. It's worse than Diddy. So, dear viewer, we're like, Ray J, what are you talking about? What is this allegation that would warrant RICO charges? How is this family the mob? I want to know. I'm super curious. That's why it's like, the first thing I did was go look for that lawsuit. He even retweeted the clip on X saying, stay tuned. And that is verifiable. That's actually where I just showed you guys the clip from. It's from Ray J's Twitter. Okay. So he did not remove it from his Twitter. It is still up as of right now. Now, Kardashian and Jenner have accused him of defamation, emphasizing that such an investigation does not exist. So they're trying to save face. So no such federal investigation exists. No law enforcement agency has initiated any criminal proceedings or investigations related to racketeering charges against Ms. Kardashian or Ms. Jenner. And no credible evidence whatsoever supports these inflammatory allegations, the lawsuit alleges. Unable to accept the end of his fleeting relationship with Kim Kardashian over 20 years ago. Ray J, they're saying you washed up. To attach himself to the plaintiff's names and exploit their prominence for personal gain. Oh, I need to read this lawsuit. I need to read it, chat. Ray J provided no evidence whatsoever for these explosive accusations, the filing says, branding the claims as blatantly false and calculated falsehoods. Alex Spiro, an attorney for the women, told Page 6 in a statement, Kris Jenner and Kim Kardashian have never bought a defamation claim before. Wow. Nor have they been distracted by noise. But this false and serious allegation left no choice. The women are seeking actual and punitive damages. Ray J acknowledged the lawsuit on an Instagram story late Wednesday night. I'm not about to be silenced. I just got off the phone with Alex Spiro. Crazy questions he was asking me. He said, y'all should be super scared because I'm not backing down. So that is where Mr. Ray J is. He's not backing down, but at the same time, think about that. The Kardashians have never, ever filed a lawsuit against anyone. Now, that is interesting. They've never done it before, but they're coming after Ray J. They're like, oh, you want to put defamatory statements out there? All right, Ray J. Let's wage legal war. So I want to know what they're allegedly, what they have against each other. Now, coming over to Instagram, I did find this. Okay. Ray J's talking about this. This was I think this came out last night. But let me refresh it and bring us back to the beginning.
Telling the truth, man. Like, I can't keep getting paid to tell a lie, bro. Like, niggas is paying me to lie. And then acting like it's okay to tell me whatever you want to tell me and treat me like I'm your slave and nigger and all this other bullshit that they trying to run towards me and scare me with, like, my life, all this shit, bro. You know what I'm saying? Niggas, weird shit is happening to us. But that's if you want to just go into our dark side. On the upside, on the upside, everything is great. Like, we made history with Kai. I love Kai, man. He took a risk on us, and we did good. And now we chilling it. And I don't want to taint his shit. I don't want to taint y'all shit. Like, if anything comes up and niggas is second guessing it, then they have every right to not fuck with us. But it's sad because we don't even be on that, bro. And that's just the story of our life until we just tell the truth. Okay?
Well, who paying you to keep quiet, Ray?
I mean,
yeah, that's like, who is paying you? What are you talking about?
like you see what situation I'm in. Like, you know what I'm saying? Like, I to say the names here.
Yeah, I don't think we should do that. I think.
You know what I'm saying? You want to talk to me after?
Yeah, we'll offline.
Yeah, because I don't want to get Zeus involved with that kind of shit, man. And I don't want to get Kai, and I don't want to get Kevin and nobody involved in some of the shit that I got to do as a man and as something that's been going on in my career. And I'm doing that shit for my daughter and my son. Like, they will not know me for something that I'm not. And I promise you, like, for the truth, I'm trying to get to the truth, or I die trying. I'm not trying to get no clout or nothing. Like, we already popping. I just can't take it. If you understood what was happening from now until like 20 years ago, all day, every day.
I don't even want you to go down. I don't even want you to go down all of that. I don't want you to go down.
All right, my bad, Lenny.
No, listen, but.
So it seems like there's some type of hush money here. That's what it seems like to me. Because it's like, what else would they be doing to you? You know? Like, what else would they have on you, Ray J, for you to be able to it has to be hush money. I think it's hush money for the tape, or he knows information about them that he is not releasing and they're paying him for it. But at the same time, if there's a defamation suit and they've never done it before, it is very interesting. I really want to know more about this. So I think for next Tuesday's show, I should have the lawsuit by then to see exactly what the claims are, but they gave us a few of those quotes. I mean, you also have to remember this. Kim did go, I think she failed the baby bar a few times, but Kim Kardashian wanted to be an attorney. I don't know if she's still focused on that. But around the time that I went to law school, and I practically threw the books because I was just like, why are we here? We have to spend all this money, but in the state of California, there is a rule that exists where it does not require you to go to law school. You would have to, I think, apprentice with an attorney for about 6 years and do some self-study for the bar exam. I believe Kim was on that path. That was around 2018. So we're just about at the 6-7 year mark. I believe there is a test called the baby bar exam while you're in law school. I've taken it a few times throughout the years. I think it's like it's in your first year, the second year, maybe the third year. I remember being tested on it and I was good. But I remember her taking it and she like failed the baby bar. So that it is what it is, to each their own. I don't know if Kim's desire is to practice law anymore, but for them to get like Top Gun lawyer like Alex Spiro, and Spiro's good. He really is. He is the reason why we found out that Jay-Z's claims, or at least that woman, Jane Doe, that Tony Busby was working with, her claims were false. She was saying that she went to, she ended up getting graped by Diddy and Jay-Z. And Jay-Z was like, nope, you're not dragging my name into this. There was a lot of things that were just fishy in that lawsuit, like, you know, the house that didn't exist, right? The woman not having a phone, walking to a gas station, living 8 hours away, and her father coming to pick her up when he lived 8 hours away. Friends that could corroborate the story that were dead. The whole thing was just a crazy lawsuit. So Alex Spiro is actually pretty good. You know, they've hired a pretty good attorney for this. I would rank him up here. So it is interesting that they've never filed a defamation suit and they're doing it here. So that's your first thing. But we're going to talk about Diddy in a second, but I could not start the day without talking about Ray J and what is going on, because he's saying that he's going to fight it. But at the same time, what do you have on them that's RICO worthy? Not even on a state level, because this was all filed in California. So I assume that he has residence or he's living in California. What do you have that's federal RICO worthy? That is an interesting question. It really is. It really is. We are going to switch gears to Diddy. Diddy, at the start of the week, here is the latest filing. He wanted to have a new trial, go from there. The judge put this out 2 nights ago, Tuesday night. And he has made his decision where Diddy is not going to get a new trial. So we're going to unpack this opinion here as well. Before we do, let me come to some super chats that came in. Just one. Shout out to D. Hits me with the 2, says AV7 with the T on Tuesdays and Thursdays. It's the T's. That's how you remember the Tuesdays and the Thursdays. It is the T. But yes, so when there is no active trial on, guys, we will be here for this quick power hour on these days and go from there. Okay, let us look at the latest on Sean Diddy Combs. And thank you, D, for that super chat. Really appreciate it. This is the judge's opinion and order. Sentencing day is tomorrow. So we're going to go from there. So here's the judge. He's a U.S. district judge. He says, after an 8-week trial, a jury convicted Sean P. Diddy Combs of 2 counts of transporting people for prostitution under the Mann Act. Before the government rested its case, Diddy moved for acquittal under Rule 29. The court reserved its decision under Rule 29B, and Diddy renewed his motion after the verdict. He also moved for a new trial under Rule 33 for the following reasons. Both motions are denied. Okay. Keep in mind that the prosecution team is hoping to give Diddy 11 years. That's their recommendation. Now, will he get credit for time served? Will he do the full 11 years? Will he get out on probation? This document is really important because we get a preview of what the judge is thinking. Is this judge going to throw the book at him? And for everybody that's sitting here in chat, type in your predictions right now. How much time do you think that Diddy is going to get? Right now, the recommendation is 11 years. Type in chat. I'm very curious to see what y'all are thinking. Okay. Coming back over here to the background. The government first indicted Diddy in September of 2024 for violations of the Mann Act, for trafficking and for racketeering conspiracy. In its third and final indictment, the government's case was built on Diddy's actions beginning in 2004 and continuing over the next 2 decades. The government alleged that Diddy arranged for and paid for men to travel across the United States and internationally to have sex with Diddy's girlfriends, Cassie and Jane. Further, the government alleged that Diddy transported Cassie and Jane's to have sex with those men, gave them illegal drugs, and physically abused them. This, the government argued, was the product of the Combs enterprise, quote, a criminal organization comprised of Combs, his businesses, and his employees. On the government's telling, the organization existed for lots of reasons, not only to run a global business in the media, entertainment, and lifestyle industries, but also to fulfill the personal desires of Combs, particularly those related to Combs' sexual gratification. Now, a big part of Diddy's argument when he wanted, a motion for a new trial, when he was saying that he was being treated unfairly, this is after the verdict came in, was this discussion around the Mann Act. Now, Diddy's argument was, hey, I was just watching. I didn't participate in those things. In fact, Cassie participated in some of these freak offs without me there. Right? And if you think about what Diddy actually got charged with, the RICO conspiracy was cleared. He was not formally charged with that. Sorry, not charged, but convicted of that. Now, if you think about the difference between actually participating and watching, there was this big discussion about voyeurism. Are you participating if you're watching? Shout out to some of you guys that are putting in your bids. Alda says 7 years. Pink says 4 to 5 years. Cowboy says end of the year, then 3 years probation. And TZ says 7 years. We'll see. We will see. Let's come back to this and see how the judge breaks down that argument, because that was a huge part of Diddy's argument. The case went to trial. After the government rested, Diddy moved for an acquittal. That motion focused mostly on racketeering and sex trafficking, but also contested the Mann Act charges. With respect to the Mann Act, Diddy argued that the escorts who testified didn't travel across state lines, that they disavowed that they were paid for sex or engaged in prostitution, and that they sometimes were paid even when they didn't engage. The court withheld its decisions and the charges went to the jury. The jury agreed with Diddy about the sex trafficking and racketeering charges, acquitting him on both. All right. So there's no trafficking or racketeering. So no more RICO. Right. But it disagreed with Diddy about the Mann Act, finding him guilty. Diddy now renews his Rule 29 motion and also moves for a new trial. Here's the legal standards that the judge used. It said, on the defendant's motion, a court must enter a judgment of acquittal of any offense for which the evidence is sufficient to sustain a conviction. Evidence is insufficient to sustain a conviction only if it is non-existent or so meager that no reasonable jury could find guilt beyond a reasonable doubt. As the Second Circuit explained in this Cootie case, a defendant challenging the sufficiency of evidence bears a heavy burden because the reviewing court is required to draw all permissible inferences in favor of the government and resolve all issues of credibility in favor of the jury verdict. There's another case that they cite from 2011. Under the Federal Rule of Criminal Procedure 33, upon the defendant's motion, a court may vacate any judgment and grant a new trial if the interest of justice so requires. Okay, so that's the rule. They're citing it, so I'm not going to read y'all all of that stuff. Let us keep going. Accordingly, the court must examine the entire case and take into account all facts, circumstances, and make an objective evaluation, keeping in mind that the ultimate test for such a motion is whether letting a guilty verdict stand would be a manifest injustice. Okay, Combs makes two types of arguments under Rule 29, legal ones about the correct definition of prostitution and factual ones about the evidence at trial. On Rule 33, he argues that the evidence on the acquitted counts prejudiced the jury on the counts of the conviction. So let's talk about Rule 29. The legal arguments in Diddy's Rule 29 motion turn on what the word prostitution means in the Mann Act. The act has two clauses. Both share the same act element, transporting somebody in the interstate and foreign commerce, but they have different intent requirements. Oh, interesting. The first clause, the one at issue here, requires that the defendant intend that the transportation person engage in prostitution. The second clause, the broader catch-all, requires that the defendant intend for the transported person to engage in any sexual activity for which any person can be charged with criminal offense. So this is what the law says. It says whoever knowingly transports any individual in interstate and foreign commerce or in any territory or possession of the United States with the intent that that individual engage in prostitution or any activity for which any person can be charged with the criminal offense. So that's a quote from the law. At trial, Diddy proposed that the jury instructions define prostitution as engaging in sexual activity for money or its equivalent. Okay, so he's citing Black's Law Dictionary. Let me look because I happen to own one and it's right here. So I'm just making sure. I'm pretty sure it's fine, but if we look up the definition of prostitution, and this thing is the Bible, guys. Like, this is what we all use to define legal concepts and legal terms. That's why I keep it on my desk here. And yeah, it is exactly how it's stated in Black's Law Dictionary. This is how we define what this stuff means. Goes on to say the courts adopted Diddy's definition in its instructions to the jury, which proceeded to convict Diddy under that definition. Then Diddy changed his mind. Now he argues that his proposed definition was wrong all along. Wait, what? Oh, man. I hope the defense team didn't make a mistake there. This is why I wanted to check. Okay, so he had a proposed definition of what it means, and that was going to be relayed in jury instructions. Now he's saying that his original definition was wrong. And in the court, when they say the court, that means the judge. That means the judge agreed with him and allowed those proposed jury instructions to go in front of the jury before they went in to deliberate. Prostitution, he says, instead requires either that the defendant have a commercial motive and that the buyer has sex with the seller. That would mean that there was never any prostitution involving Diddy, who lacked a financial motive and didn't directly have sex with any of the men he hired. Why do you guys think that he wants that made clear? That he directly did not have sex with any of the men he hired. On his telling, applying a broader definition would create constitutional problems. These arguments don't hold water for the reasons below. So the judge is like, Diddy, no. Here's the first reason. Diddy didn't forfeit or waive these challenges. The first question is whether Diddy can bring a legal challenge to his conviction on a Rule 29 motion. The government contends that Diddy should have made his challenges earlier under Rule 12, and so he forfeited them. And that the instruction given to the jury on the definition of prostitution was of his own devising. He's like, Ninja, it's your fault. And he waived any claim of error. Neither argument persuades the court. First, Diddy can bring his legal challenges under Rule 29, despite not raising them earlier. These challenges are routinely made and decided by courts in the circuit, including the Second Court itself. So he's given some examples of cases that's happened. Second, Diddy didn't waive his argument concerning the definition of prostitution by proposing the instruction for the court to give. To be sure, this case involves an unusual series of events. Combs proposed the instruction. The court adopted it. And now Diddy says it was wrong the whole time. Ordinarily, the invited error doctrine would bar this kind of challenge to the instructions. But Diddy argues that his Rule 29 motion doesn't challenge the jury instruction, but instead turns on what the definition of prostitution should be. Not what it is, but what it should be. On that view, the jury instructions aren't relevant to his arguments. Diddy is right. Okay, so he's giving him something. In Mustachio versus United States, the Supreme Court held that a reviewing court's limited determination on sufficiency review does not rest on how the jury was instructed. Though that holding addressed only whether the due process clause requires an appeals court abide by an erroneous jury instruction given below that advantaged defendant, the Second Circuit extended that reasoning shortly afterward. In another case, it held this principle also applied when the jury instructions disadvantaged a defendant. Okay, interesting. There, like here, a defendant failed to object to jury instructions, but then challenged the evidence based on a different interpretation under Rule 29. That's what Diddy's doing, so that fits. The Second Circuit held in that prior case, in answering this question, it was not bound by the district court's jury instruction. Separately from this line of cases, the Second Circuit recently got to the same place in the United States versus Dennis case addressing Rule 29 challenge, even though it turned on limiting the definition that the defendant didn't insist be included in jury instructions. The court did find the defendant's Rule 33 challenge on those instructions forfeited, but Diddy isn't making that kind of argument here. These cases support Diddy's contention that the actual jury instructions aren't relevant to his Rule 29 challenge. So he isn't barred from now arguing that the Mann Act means something different. Okay. Diddy's newly proposed definition of prostitution is wrong. This is it. This is why he lost the motion. Diddy argues that prostitution, properly defined, has two elements absent from this case. First, the defendant must have a financial motive. Okay. Next, the exchange of money for sex must be bilateral, meaning whoever pays for the sex must engage in it. Interesting. Both arguments share a similar structure. Each posits, I've never seen that word before, posits. Why don't you just say positions? Each positions, I don't know. I mean, we're talking about Diddy freak-offs and stuff. That definition of prostitution at the time of the Mann Act passage was overbroad, and in some respect, then each engages or suggests in a way to narrow the definition to avoid potential constitutional problems. If Diddy is right, then his convictions, even on an alternative theory like aiding and abetting, should be reversed because no prostitution occurred at all. That's the core of Diddy's argument. Both arguments fail. Diddy got it right the first time. The correct definition of prostitution in the Mann Act is sex in exchange for money or its equivalent. And that definition poses no constitutional problem. Okay, prostitution means sex for sale. To any modern reader, the plain meaning of prostitution is sex for sale. Every modern dictionary the court consulted says the same thing. Oh no. Oh no, he didn't. He said, see prostitution in the Oxford English Dictionary. This judge is funny. It means the practice or occupation of engaging in sexual activity with someone for payment. He even went to Merriam-Webster. The definition is the act or practice of engaging in sex acts and especially sexual intercourse in exchange for pay. Then he goes to Black's Law Dictionary, which I just validated. He has a 2024 version. Prostitution in that dictionary means the practice or an instance of engaging in sexual activity for money or its equivalent, commercialized sex. The Mann Act's history does not suggest that a different definition applies. True, in 1917, the Supreme Court indicated that prostitution as used in the statute could be for hire or without hire. That's in a 1917 case. And that appears to reflect how the word was used at that time. Okay, so we come back to the Black's Law Dictionary on defining prostitution. But the court walked away from that expansive definition 3 decades later in Cleveland versus United States, recognizing that prostitution normally suggests sexual relations for hire. And while Cleveland didn't explicitly overturn Clenney, its definition of prostitution was key to its reasoning. Interesting. Reasoning that debauchery, look at one of my words, differs from prostitution in the statute because debauchery doesn't require payment. That was the Supreme Court's last word on the matter in 1986. Then, in 1986, Congress amended the Mann Act, cementing that common sense definition of prostitution. It struck the entirety of Section 2421 and reenacting it, reinserting that prostitution clause, but cutting the laws. Oh my goodness. Looking at words like debauchery and immoral purpose provisions. Okay, so they made some changes to the Mann Act in 1986 to include certain language. That definition is also what prostitution ambiguously meant at the time of the amendment: an act of sexual intercourse or any unlawful sexual act for hire. Okay, he goes back to the Black's Law Dictionary. Okay, 1979, it was changed. Okay, he actually went to the different versions of the Law Dictionary. So he went to a 1979 one. Then he went to the 6th edition in 1990. Then he goes to the Oxford English Dictionary in 1989. And then he goes to the Webster's New Collegiate Dictionary of 1983. All this was around the time that Congress in 1986 amended the Mann Act to give us the formal definition. So what this judge actually did is he went back to older dictionaries to see what the meaning or what the definition was back then versus modern dictionaries today. And this was right around the time that Congress made that change. Sorry, sometimes I think out loud, guys. To think that Congress instead wanted to revert to Simonetti's expensive definition of prostitution disregards the entire purpose of the amendment. It eliminated provisions that had been criticized, as Combs criticizes them now for their alarming scope. It would make little sense for Congress to get rid of those provisions, but at the same time, preserve a sweeping definition of prostitution with the same effect. We're going to skip some of that. So, consistent with prostitution's ordinary meaning, how the Cleveland court understood it, the judicial state of play when Congress last amended the provision, and how Congress would have understood that term at the time of the amendment, the right definition is the one that Diddy proposed at trial, and that the court used the same in its jury instructions: engaging in sexual activity for money or its equivalent. But Diddy isn't satisfied with that definition. He says that prostitution has two additional requirements, neither of which is grounded in the text of the statute. The meaning of prostitution at the time of the Mann Act's enactment in 1910, or its meaning when the statute was amended in 1986. For the following reasons, the court rejects Combs' proposed additional requirements. Man, the rigmarole we just went through to get the answer to that question. This judge went through different versions of dictionaries before the Mann Act had a change in 1986. So he started with the statute itself. It was born in 1910. It was changed in 1986. We looked at dictionaries in the middle of that time and dictionaries after. Oh my gosh. Legal stuff is so crazy. I'm going to take a quick little super chat break and we'll get back to this. Is page 6 out of 16. Shout out to Senator. Good to see you, Senator. Really appreciate you being here today. And you're always supporting all my streams. I just noticed that. Thank you so much. Y'all check out Senator's channel. Drops me a 5, says AV. Thank you. Thank you. D hits me with another 5 and says the judge in the Diddy case ain't playing around with him. He's giving him the max, in my opinion. Yeah, the judge seems fair. I recognize his name. I do think that he presided over the Trump case in New York as well. So pretty popular judge he's getting a lot of these high profile cases. But thank you, D. Appreciate the super chat. Shout out to Drew Beats with the 5 says, so when we locking Cassie up, I think you meant Cassie. So when are we locking Casey up? I think you mean Cassie. I don't know. I do have some of these victim impact statements that we could look at as well, guys, but this is interesting. So a lot of this is a fight between the definition of prostitution, and the judge did do some diligence here to really properly explain it, right? Let's keep going. A defendant need not have a financial motive. Diddy argues that prostitution in the Mann Act requires that a defendant have a financial motive. But there's nothing in the text of the statute to support this requirement, and it doesn't make any sense in this context. Damn. Diddy wasn't convicted of prostitution, but rather transporting others for prostitution. Diddy seems to be conflating two things: the definition of prostitution and the motive of the defendant who transports somebody for prostitution. So those are two different things. We have the definition of it, and we have the motive of the defendant who transports somebody. So two big parts of his argument. The statute requires only the intent that the transported person engage in prostitution. Diddy's argument imposes an additional mental state requirement for the transporter. And gaps into the word prostitution, a word that by itself doesn't contemplate anybody but the parties involved in the sex act. What happened in this case was transportation for prostitution, even under Diddy's standing of the term. What happened in this case? I got distracted. Diddy transported the escorts who were financially motivated and intended for them to engage in prostitution. Whether Diddy himself was financially motivated never enters the calculus. There's no basis to adopt Diddy's proposed financial motive requirement for the defendant in Mann Act cases. So Diddy is basically saying, okay, I did not participate in the prostitution, right? People were transported, but I did not participate in it. I watched it. It's a little bit different, but he's really, really trying to look at the minutia here. Let's keep going. Next section, a bilateral exchange for money for sex is not required. Diddy also argues that prostitution is a strictly bilateral transaction. One party pays another for sex, but those same two parties have sex. That's exactly what I was just saying, right? I watched, but I didn't participate. That definition would narrow prostitution almost out of existence. It would exclude any situation in which a person pays a third party, like a brothel, to have sex with an employee. To support that narrow construction, Combs invokes a series of state court decisions that he says adopt his definition, putting aside that none of those decisions interprets the Mann Act, as the government points out. These cases aren't good evidence of the meaning of the word prostitution. To the extent that these cases are relevant, they stand only for the proposition that the states have defined prostitution differently within their statutes. See, that's the thing. So he did find some case law where it applied with what he's proposing. I don't know if any of them were New York cases, but the judge is like, okay, even though that's relevant, it does not apply here. The cases can be grouped into two general categories. The first group is the masturbation cases, and each of those, a defendant either masturbated in front of someone else for money or offered to. Oh, that's creepy. In each, the defendant was charged with violating the state prostitution statute. And each of those statutes defined prostitution in a way that the court interpreted to require sexual contact between people involved. So, in that situation, the people are doing it to themselves, I guess. Let's see. Citing case law that defined prostitution as sexual conduct with another person in return for a fee. Next, interpreting prostitution to exclude self-masturbation for hire without any physical contact between performer and viewer. Ah, I see where he's going. Interpreting the phrase non-marital sexual intercourse with anything of value. Interpreting sexual act for hire where state law defines sexual act as intercourse, fellatio, masturbation of another, anal, or the causing of penetration to any extent of another. Sorry for those that are squeamish. That's just that's what we're just reading. Combs argues that these cases show that prostitution requires a bilateral exchange for money for sex. Not so. These cases involved the question of whether there's prostitution when there's no contact at all between the participants. Ah, okay. So those cases that we just read up in the paragraph above are the examples that Diddy used. And that shows when there's no contact at all between the participants. That isn't the issue here, given there's no question that Ventura, Jane, and the escorts had sex. The cases didn't address whether prostitution requires a bilateral exchange for money and sex between only those participants, as Diddy insists. And even if they were relevant, those cases didn't turn on the bare word prostitution, but instead on the definitions provided in each statute. The second group of cases concerns strip clubs and commercial voyeurism. Okay, that's a good point. A few of these cases simply aren't relevant. One did nothing but note that some forms of commercial voyeurism are distinct from prostitution. In another, a court held that a dancer didn't engage in prostitution with a patron who touched the clothing covering her genitals because Missouri law required touching of the genitals themselves. But again, recall that Combs' proposed definition of prostitution turns on whether the money and sex flow between the same people, not whether the touching happens at all. Ah, okay, so that's where Diddy's defense team made a mistake. And notably in Burgess, the statute didn't require a bilateral exchange for sex and money, but covered situations where something of value received by the person or a third person undermines Diddy's arguments. So there's a difference because he did correctly state that, okay, when you go to a strip club, you're watching, right? And in this case, Diddy was saying, I didn't participate, I watched. There's a difference, right? But if you're using strip clubs, which is a place of business where people go to watch, right? They watch people take their clothes off and, engage in lewd dancing, the lewdness, there's that. Now, what the judge is saying is like, okay, but prostitution and voyeurism at a strip club, those are two different things. Remember, Diddy, you're talking to us about the definition of prostitution. We can bring up strip clubs because that's viewing, but that doesn't necessarily apply in the matter that we're looking at right here. There's a difference between watching and engaging. But if you're going to give me an example of you watched and didn't engage, it's not necessarily the same thing. The strip club is a commercial thing, but a deal with a escort or whatever that happens behind closed doors, yeah, you're watching, you didn't engage, but your definition argument is still not being satisfied here. And notably in Burgess, the statute didn't require bilateral exchange of sex and money, but covered situations where something of value received by the person or by a third person undermines Diddy's arguments. Two other cases in his category appear more relevant on first blush. Oh my goodness. Sometimes the way people write is so crazy. In State v. Taylor, courts in Arizona and California confronted the setup of a theater or a club where customers could pay to watch employees touch each other's sexually. In Taylor, an Arizona court held that the charged employee who engaged in the touching with another dancer was legitimately prosecuted under the prostitution statutes, which required sexual conduct with another person. That was so even though the defendant didn't pay the other dancer, undermining Diddy's proposed construction. And just as in Burgess, the Arizona statute made clear that the fee arrangement could be with the person engaging in the sex or any other person. So that case also cuts against Diddy. He is just taking L's in this document. All right, so he goes into another case called Wooten in California. I'm going to try to skip between that to see what else is in here. There's another case in People versus Paulino, so a New York trial court as well. All right, so yeah, he was just kind of pulling apart Diddy's cases. Let's go to C. It says defining prostitution as sex for money doesn't create constitutional problems. Diddy argues that any definition of prostitution broader than the one he suggests would create constitutional problems. He did say that. Specifically, he says that the statute would be void for vagueness, violate substantive due process rights, and create federalism problems and violate the First Amendment. Even though he makes all his arguments under the auspices of statutory interpretation, he also mounts a standalone challenge to his conviction under the First Amendment. None of those arguments are persuasive. Okay, here's why. He says they're void for vagueness. I'm not going to get into all of that. Next, substantive due process. Next, federalism. Basically, all of his arguments fail. The First Amendment, this is interesting. Diddy argues that because he's an amateur pornographer and consumer of porn, his conviction violates the First Amendment rights. That argument fails for two reasons. Diddy's conduct is not protected by the First Amendment. We're not going to go through that. Diddy's incidental filming resembles the facts in another case. All right. The other two cases where prostitution convictions are invalidated based, at least in part, on free speech considerations. Yeah, so Diddy's like, hey, I'm just trying to watch this stuff, but because I'm watching it, that should be protected under the First Amendment. Wow. I don't know which attorney wrote this, but I really hope it wasn't Brian. Second, even if Diddy's conduct falls under First Amendment protection, his conviction doesn't violate it. If speech is implicated, then the Mann Act is a content-neutral restriction that has an incidental effect on speech. Yeah, I took First Amendment law in law school, and it's actually pretty complex. You know, there's content-neutral. You know, the way that courts look at it, it's very tight. Sometimes it's more broad. Sometimes it's not. But First Amendment law is pretty fascinating. Diddy challenges only the second prong, whether the law furthers an important or substantial government interest. Oh my God, y'all bringing me back to class. Finally, though Combs doesn't mention the fourth prong of O'Brien, the court notes that the Mann Act isn't broader than necessary. Okay, we're going to keep going here. Combs is right that the Mann Act's text and application have challenged or have changed in the last century. They have, but that has little relevance to his conduct, which sits at the heartland of the Act's legitimate proscriptions. Unsurprisingly, then, his conviction raises no constitutional problem. There was sufficient evidence to convict under the definition adopted. Combs' fact-based challenge also fails. He argues that the evidence wasn't sufficient to convict him under the definition of prostitution used at trial. To sustain a conviction under the Mann Act, one of the dominant purposes of the transportation must be for the transported individual to engage in prostitution. It need not have been his only purpose or motivation, but it must have been more than merely incidental. Combs's argument all sound in the same tenor, that even if he paid escorts and they had sex with Cassie or Jane, he didn't intend to pay for sex at the time of interstate travel. Instead, he meant to pay only for their time. If they ended up having sex on that time, or even if it was foreseeable, it wasn't the object of the transaction. To support that framing, Diddy argues that the evidence at trial showed that sex was never part of the bargain. He points to evidence that the agencies that provided the escorts didn't advertise themselves as selling sex for money. What? Instead, they offered time and companionship. or alternatively, dancing and stripper services, but not sex. During the negotiation, Diddy wasn't privy to any of the details other than what are we doing and who's available. One of the escorts would have thought twice to think it was prostitution. Another, who massaged Cassie, was only there to create what he called a sexy scene. At least one of the escorts also had sex with Cassie without payment. Whoa. And felt romantically attached to her. What? Finally, Jane and Cassie sometimes describe the escorts are entertainers paid to entertain. This whole world is crazy. Like, the world that they were in is just so insane. The problem for Diddy is that the court defers to the jury's choice of the competing inferences that can be drawn for evidence, and a great deal of evidence supporting the competing inference that the dominant purpose of the transport was to pay for sex. First, evidence at trial showed that both parties in the transaction acted as if they were engaging in prostitution. Each side worried that the other side was undercover police, a concern that wouldn't have been relevant if Diddy's intent hadn't been to pay for sex. At least one escort asked Diddy whether he was a cop, and Diddy and Cassie asked multiple escorts the same. Hey, are you a cop? In one instance, Cassie says, Diddy wanted me to clarify if a person was a cop. And Diddy believed that the escorts were frequently being tested for STDs as part of their job. Example, Jane says at trial, he just said, why wear a condom? These guys are safe. They get tested all the time. Oh my God, Diddy. Second, Cassie testified that the escorts were paid to ejaculate and have sex with her, contrary to Diddy's contention that they were paid for their time and companionship. Here's a question that was asked during trial. Question: for the escorts who you interacted with, what were they paid? Thousands of dollars to do. Answer: to ejaculate, to finish. Another question at trial: for all the dancers you interacted with, what were they paid to do? Answer: to entertain and to ultimately have intercourse with me. Even the escort that Diddy claims testified that he wouldn't have thought twice to think it was prostitution and explicitly stated that he was paid money for sex and he wasn't paid, and that he couldn't, and it wasn't paid when he couldn't sexually perform. Whoa. Let me read that again. Even the escort that Diddy claims testified that he wouldn't have thought twice it was prostitution explicitly stated that he was paid money for sex and wasn't paid when he couldn't sexually perform. Diddy's an animal. Here's another question that was asked at trial. What did Cassie give you money for in and around 2012? Answer: to have sex with her. Jane testified that multiple men were routinely paid by Diddy when they finished having sex with her. Jane testified that multiple men were routinely paid after they were finished having sex with her. Third, their compensation was tethered to their performance at their job. When escorts ejaculated without having been told to do so, Diddy wasn't pleased by their performance and they would take less money. And fourth, even though some experts also spent time with Cassie and Diddy outside of sexual activity, others engaged in sexual activity on every single trip with both Diddy and Jane. Here's another question from trial. Every time you met with Miss Cassie and Diddy, what was the purpose of the meeting? Answer: to have sex with Cassie. Another question. Jane, in a typical hotel night, how would intercourse with an entertainer end? Answer: with them finishing on me. Question. At the time of each hotel night with Cabrali, what, if anything, did you give Cabrali? Answer: money. Diddy's arguments fall flat. Yes, much of this evidence comes from after the escorts traveled, but it's still relevant and probative of Diddy's intent beforehand. And to be sure, some of the escorts may have mixed motives, as Diddy points out, but the evidence still supported that Diddy intended to pay the escorts for sex and that the escorts indeed had sex and got paid. Finally, even if the government relied on some circumstantial evidence, it also presented direct evidence in the form of Cassie and Jane's testimony. And in any event, a jury's verdict may be based entirely on circumstantial evidence. There was also sufficient evidence admitted at the trial of interstate transport of the escorts, of Cassie, and of Jane, who were paid for sex. For this reason, Diddy's arguments that the escorts who testified at trial didn't themselves travel between states isn't grounds for granting relief. No new trial is warranted under Rule 33. Diddy says that he should get a new trial under Rule 33 because his RICO and sex trafficking counts shouldn't have been joined together with the Mann Act counts. All right, so the judge is going to kind of dismantle that argument too. These challenges are difficult to prevail on. As a general matter, a Rule 33 motion should be granted only with great caution and in the most extraordinary circumstances. And on top of that, a defendant arguing prejudicial spillover bears an extreme heavy burden. Okay, so they talk about when it would apply. The court declines to reject Diddy's argument without reaching the test. Conclusion: for these reasons, Diddy's motions under Rules 29 and 33 is denied. So he's not getting a new trial. He's not getting a new trial, and that definition argument, and for us to go through all of that, it's like, okay, there's a difference between watching and doing it, the intent for payment, lots of legal discussion there that would make your head hurt. I'm going to come over here for a second, and then we have some victim impact statements that I was able to dig up, one of which comes from Diddy's baby mama, the Asian woman. I think it's Baby Love's mother. So we have a statement from her, and we're going to go from there. Also, you know, Diddy's team is fighting the 11 years. So I do have that letter as well to make sure that, you know, they want to make sure that their client doesn't get the maximum sentence. So I want to see what the rationale behind that is. Shout out to For Always, Forever, For Life. Been with me for 15 months. Says, hey, AV and Chatterhood. Hey, we're doing a brief power hour. Good to see you. If you are a member, you do get one of these once a month. Oh, and I'll do it right now, actually. The other thing I can do as creator is I give you guys, YouTube gives me 10 memberships to distribute on their channel the first of every month. Today is the second, but I have 10. So I am going to gift y'all 5 memberships right there. And then we are going to do the other 5. I try to make sure I do this at the start of every single month. So John Coe got a membership. Jameson got one. Miss Zinzin got one. TW got one. Holy Lala, Felicia, Cowboy, Christy, Lynette, and Grave just got my October membership. So really happy that y'all were able to get those. For Always, Forever, For Life just reminded me with her membership for 15 months. Shout out to Brother Irwin with the 10, says, master for money. Oh yeah, masturbation for money is hilarious. I mean, Diddy threw everything in that. He's just, I mean, it's the last ditch effort. What can you do? Is he going to get the 11 years? I'm still taking bets. What do you guys think it's going to be? What do you think it's going to be? All right, this here is Diddy's final effort in trying to make sure that he doesn't get the maximum sentence. This was yesterday. Here it goes. It says, we write in opposition to the government's letter requesting that a person with a false name of Mia speak at Diddy's sentencing for charges of which is not in a statutory victim. Oh, this was the, this is not the 11 years. There's a woman named Mia that they don't want to speak at the sentencing hearing. I think it's his former assistant. Over defense objection, Mia was permitted to come into the courtroom, assume a fake identity, complete with a made-up voice and demeanor, and lie about the defendant in a criminal case, all behind the shroud of anonymity. She lied that she had sexual contact with Diddy without her consent. She lied that she was a victim. Virtually everything that came out of her mouth was a lie. One of the great vestiges of the Enlightenment that once held sway over parts of Europe is trial by jury. And jury of 12 people had little difficulty concluding that this person with a false identity, voice, and demeanor was lying, and it acquitted Diddy of anything and everything related to her testimony. Thank you so much, James, for dropping those memberships. I'll read them out in a second. But she apparently is not done. Now that the jury is gone and her lies will not be tested by cross-examination or evaluating by a fact finder, she wants to return to court, still beneath the shroud of anonymity to lie again. Simply, she is not a victim of anything. She had adult sexual contact with Diddy on a handful of occasions, and as her many writings show, held him in the highest regard for years afterward. How do we know this? The same way the jury knew, because her testimony was blatantly incredible in every way, as was a testimony of so many of the government's witnesses. Moreover, that she is so eager to return to court when she plainly does not have to and is not entitled to, puts her proffered fear of testifying at trial into clear relief. This was a show for her. She got to lie. She got to testify with a false identity. She got to try out her fake voice for a jury of savvy New Yorkers. But she also saw the consequences of lying to a jury. They don't believe you. So now that the jurors have returned to their lives and she can testify without scrutiny, she wants to come back, still under a fake name, still with the false narrative to further sully the proceedings. Thank you for your consideration. This is all Diddy's team. So they do not want Mia to come back. Allegedly, this woman has lied on the stand, and they're trying to keep her away from the sentencing hearing. So that's what you're seeing there. Okay, coming over to the baby mama's letter. Let's see what she has to say. She says, "Dear Judge, I know you're sentencing Diddy on Friday, and I've been thinking a lot about it. I saw in the press letters that were submitted by so many concerning the sentencing. No one asked me or told me to write this letter, but I felt my voice should be heard as I was identified as victim 3 in this case, and I understand the charges that were brought concerning me, including accusations of sex trafficking and prosecution. I cooperated fully with prosecutors. I met with them 3 times, answered their questions, gave them all the information and evidence I had, including pictures, videos, text messages from my phone. During those meetings, I felt pressured to feel like a victim. I told them I was not, but they insisted that I was, even when I expressed my truth otherwise. I understand they concluded that I had been sex trafficked and involved in forced prostitution. I did not agree with that conclusion. I was not trafficked. Whoa. I did not engage in prostitution with him or others. That would have been my testimony if called to the stand. I was subpoenaed and fully prepared to testify and answer all questions truthfully, but I was informed by my lawyer that I would not be called to take the stand. I want to emphasize that I understand the seriousness of this case and pain others may feel. I cannot speak for anyone but myself. In terms of sentencing, I kindly ask that you consider releasing him back to his family. I understand throughout the process he has been cooperative and respectful, including turning himself in. Throughout this process, he has never once reached out to me or made me feel uncomfortable in any way. I believe he will continue to be compliant with the court's conditions upon release. I understand that accountability is important. I am not writing this to dismiss the gravity of the charges, nor criticize anyone. I write to express my perspective as a so-called victim. I write to express how I felt during the investigation and trial and how I feel now waiting to hear the sentence. I felt compelled to share my own perspective honestly. I respectfully ask that you take my words into consideration when making your decision. Thank you for your time and for allowing me to be heard." Shout out to Virginia. So that came out. We have a lot of people coming out to speak on Diddy's behalf. Not only, and this is just an example of one of the letters that were received, but we also have a slew of letters from a lot of people. He had fellow inmates submit letters, people that used to work with him at Bad Boy, other record executives. Lots of letters have been sent to this judge. Now the judge has a decision to make. After somebody is sentenced, the prosecution's team is usually going to give a recommended sentence, and that is the 11 years. Does the judge have to do that? No, does not have to do that. He can go light on Diddy. He can go medium on Diddy, give him credit for time served. But from that last, that last document that I shared with you guys, and just seeing how he's looking at the argument, in this judge's mind, he pulled out blacks, okay? He's like, prostitution is prostitution, dude. Like, he pulled it out. We went through this long, drawn-out discussion about what prostitution means. So I don't think he's going to take it light on him. So we'll see. We will see. Shout out to James Jameson, who drops 5 gifted memberships. I didn't catch who got it. Maybe I still can grab it in the feed. Yes, the real Trisha got one of James's memberships. Lynette got one. Dollar got one. House of Brands Design Agency got one. And Danielle W. received one as well. So it's going to be a lot. But thank you so much, James. And if you received a membership from James, please say thank you to him. But it appears that Diddy's, we're gonna hear tomorrow. I am going to say maybe like, we'll go with the 7. I think he's gonna give him 7 years, some time served. But is he coming home? I don't think so. What do you guys think? A few of you guys have been giving some. We've been talking about it all stream. 4 years. Caesar says he's serving jail time. Felicia says he's gonna get time served. James says pimping ain't easy. Brandy says the baby mama doesn't count, unfortunately, because she's not really fair game, has a family connection. That's right. She wants him to be in the kid's life. Ron says, nope, he doing time. Valeria says, not coming home. Not coming home. James says 5 to 10. I'm not reading that, Caesar. Jay says miscarriage of justice if he is not let go. I mean, the baby mama letter is interesting, though. Because if the if the prosecution was pressuring her to become victim 3 and she's just like, I'm not a victim, that is important. And that could be the other significance of her letter being released, right? Like, I want the world to know that I am not a victim. They didn't even call me. I was supposed to testify. They didn't even call me. Tamara says he's not getting out. Brandy's not predicting. She just wants to see. She just wants to see what happens. Me too, sis. Latina says, I think he's going to get above 11 years. Could be wrong, though. Could be wrong, though. Greg says 84 months. You guys have some pretty interesting predictions. So we're going to see what's happening. Oh, Caesar says, explain the Mia thing again. Yeah, so this letter, apparently, and again, the Diddy trial was going on around the same time that the Karen Reed trial was happening. So I couldn't be in 2 places at once. I did think about going down there, but the big issue with the New York court system is that their trials are not televised, right? Not only are they not televised, this is also a federal case. Federal cases in general are not televised. So we could not have eyes and ears in the courtroom. Now, a lot of people were getting creative on YouTube. Some people were like making AI versions of what happened on the, what happened in court. Some people were reading the transcripts, which is super laborious. You guys know I can't stand reading some of these documents. I just got a headache from the judge's 16-page order just now. But thank you, Adriana, for the clarification. She says, AV, Virginia's not the BM. She was the girlfriend witness who went missing. Okay, so they couldn't find her. Okay. Thank you for that clarification. Sir Night Wolf says, Diddy has done some horrible things. I know someone that worked with labels out in New York. She said Diddy deserves all that's coming to him. It's crazy. I got distracted with that clarification, Caesar. But yeah, so Mia apparently is a witness that was not truthful. And I do remember hearing that one of the witnesses got caught lying on the stand, and I think it might have been Mia. Don't quote me on that. But anywho, this Mia person wants to attend the sentencing hearing, and this letter is basically Diddy's defense team saying she lied. There's proof of her lying. Please do not let her come to this sentencing hearing. That's it. Primo says, are you going to cover the Kirk case if you guys want me to? If you want me to, we will. I generally try to stay out of politics. I mean, that's hard to say because, you know, we did cover the Trump RICO case down in Georgia, but that's because we knew a lot of people in the courtroom. Ashley Merchant, along with others, Steve Sadow has been pretty vocal. That was really because of the attorneys. But if you guys want me to cover the Charlie thing, I'll cover the Charlie thing as things come out. I do know that the alleged gunman, or not even alleged, the gunman was in court, I think Monday. Today's Thursday, so he was in court earlier this week. If y'all want me to keep track of the hearings, then I will certainly do that for you, because I believe those are televised. Rolla says, why are federal court cases not televised to the public? That is a good question. Everybody's been asking for transparency for years. I did ask Ashley Merchant when she was on last year about that. It was either her or Doug Weinstein, and we had a long discussion about it. It has something to do with, it's just not mandated just yet. States have jurisdiction and they can choose. I was actually just on the phone with somebody about this yesterday, because states get to choose, right? But those are all different jurisdictions. You have 50 jurisdictions. In Georgia, they are very open about showcasing the proceedings, right? But the state gets to decide. Even judges get to decide. Some judges have YouTube channels where you can televise court hearings, things like that. Georgia's one of those states. Florida, we just watched the Adelson case, right? So we're able to see what's going on in Florida. California is pretty open. We saw 2 cases this year out of California. We saw ASAP Rocky, and then we also just saw the Cardi B case. Shout out to Emily D. Baker. I think she's rerunning that. I saw her doing it yesterday and today. But California is also a state that allows for open hearings. New Mexico, Alec Baldwin, we saw that trial. Massachusetts, not all things in Massachusetts, but we just saw Karen Reed. But notice that you're not seeing law and crime in every single state's courtroom, because it really is on the jurisdiction that you're in. Now, I say all that to say that the feds are its own jurisdiction, right? And that's a little bit more complex because federal courts are broken out, and it's like a big map. I think it's like 12 circuits, but it's broken out into circuits, right? So like Circuit 1 is like, mostly the Northeast, right? I'm just giving you an example. And, I don't have the map in front of me, but you'll see that. So it really depends on the situation. But for federal cases, I just don't think that we're there yet with transparency with the federal government. But that's their decision, right? So hopefully in the next few years, we'll see that. Thank you, DB. Yeah, federal courts definitely have different districts as well. So long drawn out answer to your question, but hope that helps. All right, folks. Well, we are just about at the end of our Power Hour. Really want to thank you guys for the new schedule. We will be doing a lot more of these. I will be polling y'all behind the scenes for different topics for the Tuesday, Thursday streams, but I will be here around noon on Tuesdays and Thursdays covering all things legal until we get to, the Courtney Clenney case. I am starting to do more on that. For those that don't know, here is a short news clip, because this, I believe, is the next trial of the year. It starts on December 1st, but we might get some stuff before then. Let us, for those that are not familiar, get caught up on the case and go from there.
We begin tonight with a major development in the case of the OnlyFans model accused of killing her boyfriend.
CBS News Miami has confirmed the parents of Courtney Clenney have been arrested.
While her mother and father are in jail in Texas, Clenney's attorney is lashing out at prosecutors in Miami. CBS News Miami has learned that Kim and Deborah Clenney were arrested at their home in Austin, Texas, and booked into the Travis County Jail. Their daughter, Courtney, is facing second-degree murder charges for the death of her boyfriend, Christian Obumseli, in April of 2022 in Miami's Edgewater neighborhood.
I'm the father.
Kim Clenney testified in November of 2022 during a bond hearing for his daughter. He was asked how far he would go to help her get out of trouble.
You would do anything for her, as well as look over her finances, but if it came to it, you would lie for her.
No, I would not, and I resent that accusation.
Courtney Clenney claims she stabbed Obumseli to death in self-defense. Videos show the couple's rocky relationship. This one, released last month, shows the couple fighting during a trip to Aspen 2 months before Obumseli died. In a statement to CBS Miami, Clenney's attorney said the charges against her parents could be an example of prosecutorial overreach and misconduct. It appears excessive, the statement says, in that the family is now confined in jail awaiting an extradition hearing on what may be an attempt to manipulate media headlines. The Clenneys have quite a story, and it's a story the state of Florida may not want the public to hear. Courtney Clenney's parents are expected to face a judge in Texas tomorrow. We'll monitor it and bring you the latest on the story right here on CBS News Miami.
All right, so that catches you up. Here is the docket, right? There have been several things that have come out when it comes to Clenney's case, but I think we're getting closer than we think. It looks like there's a bunch of depositions, but I did find this. It's not here, so I don't have the document, but she did file a motion to dismiss about 2 weeks ago on September 10th. So she wants this case dismissed. I think that's going to be denied, but they're still doing depositions as of right now. The trial hearing is scheduled for December 1st. So that is our next trial. We are starting on December 1st. And within these next few weeks, I will be doing a bunch of short videos to catch you guys up on this girl. I think she's crazy. I think she's crazy. There are multiple pieces of evidence that we're going to review leading up to trial. There is security footage where it's not even just the elevator fight. There are, like, his phone, his friends that were around him and her fighting, they would take their phones out, right? And they would start secretly filming the fights because the girl was wild, right? She was really wild. And here's her claim. She claims that she threw the knife from across the room. It just flipped. It flipped. And it landed in his chest. And that's how he died, right? And she threw the knife in self-defense, but she did not mean to kill him. All right, Miss Motion to dismiss the trial, right? The man is dead, and his family is not happy with the outcome. Kind of like the Karen Reed, the Karen Reed debacle. Christian's family also has a civil suit against this woman as well because, for wrongful death. Even just the way that the knife, I'll show you guys, we have all of that stuff. We have the measurement of the wound and the measurement of the actual knife. I think I actually have the same knife set in my kitchen if y'all really want to get granular. But the story that she's selling, what she is saying, it's physically impossible. This girl looks super guilty. And the public sentiment is keep her in jail. Do not let her out. So we're going to get into that one. It's very Chucky-like, Isabel. It's very, very Chucky-like, but that is our next case. And I'm actually kind of looking forward to it because they moved her trial back 3 or 4 times. So interesting stuff. But anywho, I'm going to get out of here for today's Power Hour. We are going to probably do a birthday stream on Sunday, heading out for Vid Summit on Saturday. So I will still do our Tuesdays and Thursday streams. Lots of legal news coming. Diddy tomorrow. Keep an eye on the community tab post and on our Instagram. I'll probably do something short to let you know what the final sentence is, why, and an immediate reaction. But we're not going to stream. I'll give you guys a shorter video though. She's a Chuckisha. Chuckisha. That's funny. All right, folks, thank you so much for supporting the stream, giving me an hour of your time. I will see you in the next one. Stay safe out there. Bye.